Hello everyone, my name is Sanjay Bandari, and today in this session of Amrut cohort, I'll be discussing about intellectual property. Why is it so important for startup companies? First, a quick introduction for myself and also about my journey in this world of IP. I'm a founder of a semiconductor startup in Silicon Valley, California. I have been chief technology officer for two US semiconductor companies for over 12 years. And prior to that, I have been involved in a lot of innovation myself in terms of all the design. Worked at a lot of multinationals like ST Microelectronics, Philips Semiconductor, National Semiconductor, but also spent 22 years in startup companies. And that's how I came to value the importance of intellectual property. I have filed more than 65 US and foreign patents, and 39 of these are granted, 23 of these are US patents. I have been head of corporate IP for 13 years. I've been advisor to University of California, Santa Barbara here in California. And I also drove multiple M&As sitting on both sides, on the acquirer side as well as on the acquisition side for multiple companies. So all the discussion, all the knowledge that I'm sharing today regarding intellectual property is really coming from my own background and my own experience in this field. Just a disclaimer, I'm not an IP attorney. Uh, I'm a fellow innovator, just like many of you are, and also a fellow founder, like many of the companies who are participating in this core program. So with that in mind, let's get started. The first thing that I want to talk about is what's intellectual property and why is it so important for startup companies? And how do we create that? How do we protect that? What are patents, trademarks, copyrights, trade secrets, and so on? And when this session is shared with all of you in that particular week, we'll have 1 hour Q&A session with all the core participants. So at that point, you can raise all the questions that you have. So first, intellectual property is any creation of mind, inventions, literary or artistic works, symbols, names, images used in commerce, etc. We categorize that as industrial property, which is patents, trademarks, trade secrets, industrial designs, geographical indications, and copyrights, which are literary works like novels, poems, plays, film, music, artistic works, and so on. And the reason I wanted to share this slide is many times people believe or they equate intellectual property to just patents. But the rest of those things are also important. Trademarks are equally important. Trade secrets are very important. Industrial designs are important, and we'll see how we treat that in the intellectual property. And on the other hand, copyrights are also important. For example, on these slides, you can see the symbol there, copyright symbol, and my name over there. What it implies is that somebody cannot just take these slides and call them as their own slides. So that's what the copyright implies. Now, why is this IP, intellectual property, important for startup companies? Since we have this webinar specifically for these cohort startups, I want to spend more time on this question, and so that it's communicated to all of you. First of all, every one of you as a founder or as an entrepreneur have certain ideas, and you work on those ideas for few months, years, tens of years, and you create a value. You come up with a product or a service that then you want to sell and make money on that particular idea. Now, what prevents one of your competitor companies from just taking your idea, the product that you developed after so many years of hard work and so much of innovation, and just creating another copy of that and start selling it next day? It's a lot easier for them if they have to just copy it instead of innovating that. And to protect that right of a inventor worldwide, this intellectual property or patent rights have been recognized. And the idea behind that is it's a barrier to entry for copycats. And believe it, I have seen it across multiple geographies. These things happen that people take somebody's idea and they try to get there quickly. And in that process, they may infringe that idea. So, if you want to protect your idea, the best thing that you can do for yourself and your company is to file that intellectual property so that somebody doesn't just easily take that and start competing with you. And at that point, reduce the value of your own company. So that's the first thing. That's the reason that you want to protect everything. You want to file patents. Now there are other benefits of filing intellectual property, and these are licensing deals. At some point in companies, you may develop your own patent portfolio, and if the patent portfolio is strong enough that your competitors value that, then at some point they would be open to that negotiation to say, okay, you share your IP with us, we'll share our IP with you, and we'll not sue each other. So whenever that negotiation is helpful to you, you can do that. The third thing is valuation of the company. In a startup world, all of you would raise money in terms of funding for your companies. And for that, your company would be valued at certain dollars, certain rupees, and so on. And that valuation is depends on number of things. It depends on your revenue, in terms of your team, in terms of your expertise, differentiation, and so on. But it also depends on the intellectual property that you have. So that's the reason it's also important for startup companies to have your own patent portfolio, your own intellectual property portfolio. The fourth is cross licensing, which is similar to the licensing deal. Licensing deal could be a monetary deal, by the way. You can license your patent to a company or certain organization and make money from it based on their usage of your patent. Cross licensing, on the other hand, means that it's you're exchanging your patents in lieu of getting rights to using somebody else's patents. So it's just patents versus patents. You can also sell IP. There is a monetary value to that, depending on how valuable your ideas are, how valuable your patents are. You can sell that to prospective buyers. It's not in an open market. You'll have to find people who are good at negotiating this or selling this IP. I wouldn't say just file for the purpose of selling IP, but once you have that portfolio, you can decide whether you want to get some monetary benefits out of that. And then there's the competitive age in this world. As long as you have a good idea on a good product, there is always going to be competition. So if you want to stay ahead of that competition in terms of your own innovation or your product being better compared to somebody else, then you need to have your own IP portfolio for that one. You can also use it to sue other companies if you believe that they're using your IP into their products. So you find that out and you can go after them. So that's typically corporate war. You see a lot of examples of that, of big companies in every field fighting for patents. And the last one, but not the least one, is royalty. There are several examples of how much royalty companies can get out of good patents. And I always like example of one of my previous companies where I worked, which is Philips. Philips had IP in compact discs or CDs. And there are billions of these CDs sold worldwide. And Philips got a good share of royalty out of that innovation or invention on CD. So now that we have seen why patents are so important, one might wonder what prevents people from filing patents. Why is not that every company, every individual filing patents? And there are a number of reasons for that, and we need to understand that because all of you have been in this place now where you may or may not have patents. You may not have filed patents for your company. So there are a number of reasons for why people don't file patents. One is the lack of awareness that the importance of intellectual property is not well understood. And this happens in several geographies where we can see that some countries, the ecosystem in terms of filing patents is quite mature. So in those countries, corporations file a lot of patents, whereas in some other geographies, that awareness is just coming up. So because of that lack of awareness, the ecosystem is not well developed. So now we are at a point where all of you hopefully have access to this ecosystem of patenting and this awareness. That's the reason of this webinar here. The second thing is people believe that's not a priority. It's something nice to have. And that's not the case, as we have seen from the previous slide. For startup companies, there are a number of very critical benefits that you can get out of your patents. The next one is cost, and which is not insignificant because patenting does cost a lot, both in everywhere, wherever you are, whether it's in India, whether you are in the US. Filing a patent has certain costs. Maintaining a patent, annuities on the patents are very expensive. IP attorney fees are very expensive. So that could be a reason for patent filing. Fortunately, for startup companies in India, now government, both at state level and central level, have come up with a lot of incentives for you to get reimbursed, for example, on your patent fees and so on. So we'll post. I believe there is information on that that was shared a while ago, and maybe we'll update that and share on Garze Marathi's website, so that you have access to that. And while you are going through the journey, while you are patenting, you can refer to that. The next one is don't know how to patent, and that's not uncommon. Some of you could be very technical background. Then while you might come up with good ideas, you may not have really the knowledge to write that patent up. And that's where the IP attorneys or IP lawyers come into picture. They will help to craft out that patent idea into a format, legal format, that will be good to file on a IP or patent office. The next is resources. I keep on referring to IP lawyers or IP attorneys. That's the resource. Those are the people that have gone through this education of filing patents, and they know how to convert this into legal language that eventually becomes a basis for having these patents being valued. If your patent is too narrow, although the idea might be there, somebody else might just go around it and then try to just file their own patents or come up with their own product ideas, which are not narrowly different than yours, and they might get away with that. So that's why it's important that you consult with IP attorneys or whoever are experts in IP when you are trying to file these patents. The local ecosystem that values patents, that's also important. I think that importance or that awareness is coming everywhere now. So make use of that awareness now. Now, the next thing that's important is what can be patented. This is important. Everybody likes to have patents, but then it's very important to understand really what's the subject matter of patents. So what's patentable is a process or method, a machine or circuitry in the sense of, for example, integrated circuit designs that we do, or electrical circuit designs that we do. Manufactured articles are patentable. New compositions, such as pharmaceuticals, for example, all these pharmaceutical companies do file patents. Now, what's most important in that patent getting granted is that novelty must be there. It must differ from knowledge that already exists. The knowledge that already exists is called prior art. So your idea, you should be able to prove that it's differentiated from prior art. And you must not have disclosed that at least more than a year ago to somebody. And that's where it's important, if you have come up with ideas, to first protect that idea or first file that idea before you start disclosing to multiple people. Once you start doing that, that becomes public knowledge, and then at that point, it's hard for you to claim a right to that, because if it's a prior art at that point, then or public knowledge at that point, you may not be able to patent that. There is a utility requirement on patents, so it must be useful. Uh, but the exception to that is design patents. And what I mean by design patents is I can come up with a particular shape of a object. It could be a consumer device, and I could come up with a shape. Now it's very hard to prove to somebody that this shape is really useful, because it's just a shape, right? But you could file a design patent on that, saying, okay, this particular shape is a patent, and for such and such reason, and it's a novelty, and so on. So these are design patents. They are different, than they are treated differently, they are filed differently compared to the utility patents, where you have to show, you have to prove that your ideas are useful. And again, most important thing is it should not be obvious from prior art. Most of the time, when you file a patent, the patent office, whether it's the Indian patent office, US patent office, or European patent office, and so on, the examiners there would compare that, and they are subject matter experts. So they would look at prior art in that, but they would also look at whether it's obvious from one of the prior art. For example, uh, if they believe that, oh, based on this previous patent that was filed 2 years ago, that somebody could look at that and then just do this very obvious modification to that, and that's what your patent is. If they are able to prove that, then at that point, the clause is called non-obviousness. And from that, patent office or patent examiner can reject your patent. What cannot be patented? That's also as important as what can be patented. So just idea cannot be patented. It has to be embedded into something. A mathematical formula cannot be patented. Naturally occurring substances cannot be patented. Laws of nature cannot be patented. Process done with human body cannot be patented. For example, you cannot say, okay, I'll swing it this particular way and now this is my patent. So any cricket player is not able to, or a bowler is not able to ball that particular way. So that cannot be done. It's a human body motion. Similarly, just idea, for example, I'll go to moon by using certain space vehicle, that cannot be patented. You have to be very specific, saying this is my design, this is how much force I'm going to put into it, this is how this thrust is going to be there in this particular object that goes from here to moon, and so on. So unless those specifics are there, you cannot just file a patent on the idea that this is a vehicle that will go from Earth to moon in certain amount of time, and so on. So now you can think about several areas where everybody says, okay, I have an idea, why don't we build this thing, and so on. But unless you give specifics of how you're going to build it and prove that this is not a public knowledge or common knowledge, it's not patentable. Where should you file your patent? That's the next question. We will see later on that there are, you have you have choice of filing patent in your own geography. For example, if you're from India, then you can file patent just in India, or you can file it in India and some other countries, including US. Or you could decide to file it everywhere on all the patent offices, which would include European Patent Office, PCT, which we'll talk later on, with Indian Patent Office, and so on. Now, what prevents you from doing that, or what's the criteria for doing that, is where is your competition? Where do you want to protect it from? If your competition is going to be only in India, then you can just file in India and that's good enough for you. On the other hand, if your competition is global, that your competitors are going to sell it in US, Europe, everywhere, then you have to file it in those territories as well, in addition to your own home country. Now, I say home country because sometimes there is a requirement that you first file into your local patent office, whether it's India, US patent office, before you do foreign filing. So look into those specific requirements. Your patent attorneys in your areas would be very knowledgeable about those requirements. The next thing is cost of patenting in those territories, because you might say, then in that case, why do I think this much? I'll just file it everywhere and I'll get patent granted everywhere. But there is a huge cost to that. It could cost you here, for example, in US and then Europe and so on. If I have to file everywhere, it could cost me anywhere from 50 to 100,000 US dollars. So that's why it's very important. And even we sitting here in California, US companies, we don't file it worldwide without a reason. We try to narrow it down into geographies that are important to us. Ability to protect in those territories is the next criteria, because you might want to file it everywhere, but then you may not have abilities to protect it in other territories. So just think about that. There are known examples of that. So you have to very carefully consider where you can protect that. Ideally, you can protect it everywhere, but that's why there are patent treaties. But you have to be really knowledgeable in terms of what to patent, how to patent it there, so that rather than protecting, you're sort of giving away the recipe to some of these other geographies. Okay, so to protect your patent rights for all the innovators worldwide, there are certain international patent treaties. These are very important, because if these were not in place, then the patents would have lost half of their meaning. For example, if I'm filing patent in Europe and somebody else, another innovator, is filing patent in Europe from that side, my patent should be treated equally to the patent that's locally filed over there on the basis of my priority date or the filing date or my idea date. So that's important. So there is no discrimination in terms of the local person filing versus somebody outside filing on the same office. So for example, on the US patent office, if somebody from India files there, and that is date wise ahead of somebody who has filed from US, then the Indian innovator would be getting the claim first. So as long as it's processed first and it's granted first. So these patent treaties are meant for that, so that patent laws and processes, although they differ from country to country, the rights are preserved when you have a patent filed into those countries. But the laws or the processes differ from country to country. For example, when do you do foreign filing? From how much time do you have from your local filing or the first filing to doing foreign filing? That those are the specific laws, and then you need to consult your patent attorney or patent law firm to find out the details about that one. There are two important treaties. There are few more, but Paris Convention Treaty, there are 176 members, including the United States and India. So each member country guarantees the same rights to foreign inventors as their own citizens. So this is the point that I was making earlier. And it preserves the original filing date as long as the patent is filed in other country within certain duration. So it's 12 months for USA for patent, 6 months for trademark and industrial design. So that's important that you have to file within that time period. There is another treaty, which is called Patent Corporation Treaty, PCT. And there are 148 members, again, including US. So this provides a standardized application format and centralized filing. For example, PCTs, if I were to file it in Japan, I would file a PCT patent. It gives me rights into those other countries as well. So for example, I mean, just to take this as example, if I'm a innovator sitting here in US, I would file I would file a patent on US Patent Office, and then I could file a patent on PCT. So that gives me rights to these countries. But then each of the European countries might require a filing into each of those territories as well. So I may decide to file European Patent Office. In addition to that, in European Patent Office, I have to specify that I want to file into countries XYZ, It could be France, it could be Netherlands, Germany, and so on. And when I file into those countries, then we have to make sure that it's translated into that particular language and filed onto that particular patent office. So it's a pretty cumbersome process if you have to file in those different geographies. You have to make use of the resources in that particular country because they kind of know the local laws better. And if you work with certain patent law firm, these law firms usually have their counterparts or their contacts in other countries, and they'll probably handle this matter for you. Let's talk about patent process. People are always curious. Okay, we talked so much about patents. What's the process here? So I kind of modified a quote that was from Edison. Edison had said, "Innovation is 1% inspiration, 99% perspiration." So I just modified that to replace that innovation by patent. And that's based on my own experience in this area. Patent is 1% inspiration, 99% perspiration. And why do I say that? Because idea comes to your head, and then you say, wow, this is the best idea since sliced bread. I should file that as a patent. But then to convert an idea into patent, there are a number of things that you have to do. Of course, you can say, okay, I file it right away. I don't want to wait for anything else. That's your choice if you have a lot of money. But in most cases, in regular cases, this is what happens, that once you have idea, that you document it in a hardbound notebook with witness signatures. Now, in the modern times, this process, this second step has been simplified, especially in corporations. There is a automated electronic process, electronic documentation, if you will, that several companies have. Our corporations had that as well, where instead of documenting in hardbound notebook, you can file it electronically within your corporation, and then it follows the process. So your electronic filing is equivalent of writing it down on a hardbound notebook, and equivalent of witness signature is when this your your claiming of this idea or your write-up of this idea in electronic format reaches to whoever is the IP firm or CTO of your company. Then you have to prove that the idea works, it's practical, and it has significant benefits. Even if you are part of a corporation may not go ahead and file it unless you prove to them that the idea works. Because remember, they're going to spend thousands of dollars or hundreds of thousands of rupees on each of these patents. So you have to prove that. Now, many of you could be inventors in your own companies or founders or entrepreneurs. And for you, it's the same game because you have finite amount of capital. You have finite amount of rupees or dollar amount. So you want to use it wisely. Yeah. So before filing patent, before spending that money on filing patent, you would first make sure that the idea works. It's worth filing. It's worth spending this much of money on this idea. So typically, then you go through this process, and that's the process that takes quite a bit of perspiration. There is part of that is what we call as a prior art search, which means you have to see whether this idea similar to this has been used in the past by your competitor, by somebody else. Now, this is a very hard process because at this point, there are millions of patents out there. How do you search through these to find out whether such a patent is there or not? So usually you take help from patent lawyers. Again, patent lawyers are subject matter experts in that particular area, in their own areas. So they know sort of how to sift through these existing patents or prior art quickly enough that they can tell you, yeah, this is novelty. No, that there is a patent before that. Then you are convinced and you have done work and you are convinced yourself and your other managers, your co-workers that this idea works. Then you start putting together a patent application and claims. And then you hand it over to your IP attorney who will translate that into nice legal language. And then that's filed at a patent office with the help of a patent attorney or law firm. So that's the process. There are many milestones in the patent process, and there are some terminologies. So just in terms of those terminologies, I wanted to go over that. Provisional patent is something that you file to protect your filing date or the filing of idea. But there is certain duration given to these provisional patents. In US, it's 1 year. Within that 1 year, you have to convert it into what's called as a non-provisional patent. So provisional patent is like a temporary placeholder. Non-provisional is the one which is finally applied there. The reason I wanted to also share that here is we ran this type of codes like Amrut cohorts over last few years. And I have come across entrepreneurs who tell me that, oh, I got a patent. And I say, okay, where is your patent number? And it turns out that they have actually a provisional patent application. So they consider that as a granted patent, and that's not true. So that's the reason it's important to understand the differences between this. Provisional patent, you file that because it costs less. And until if you want to buy in more time for validating your idea, then you can go ahead and file provisional first. Then it gives you a certain time. Here in US, it's 1 year, and then you file non-provisional patents after that. If you don't file non-provisional within that year, then the provisional also lapses unless you refile that provisional. So that's the important part of this message here, that there are steps of doing that, but if you don't follow the steps correctly, then you might lose the whole patent idea by itself. Then once you file non-provisional, that's the time that patent office will assign certain patent examiner to your case. And this might take time. It might take years for a patent examiner to be assigned to your case. But once the patent examiner is assigned, then he or she will go through that patent, look at the prior art and so on. And at that point, either they might grant you patent if you're lucky, but most cases, they come back with a lot of questions, and that's called office actions. And the questions are saying, okay, this claim is denied because of XYZ reasons, because it's a non-obviousness from the prior art, or this is exactly same as the prior art, and so on. So they list that, oh, we have looked at these patents, they look similar to you, they have been already approved patents in the past. So because of that, your patent cannot be approved. So once that office action is issued to you, then within a certain time, you or your patent attorney, or together both of you, have to work on that and respond to that, saying, okay, we understand your objection, but we believe that this is a novelty because of this XYZ reasons. And you go back and file that response to the office action and so on. And this can happen several times. I mean, I have gone through this multiple times too. I have been also lucky in few times that the patent got granted right away. Now, once the patent is granted, okay, that's Eureka moment. Then not Eureka, but also the celebration moment that you got a patent on your name. But then at that point, you have to decide whether you want to foreign file that, or there might be a certain duration within which you have to foreign file it. There is another thing called continuation in parts, so you also have to decide about that. You have to pay annuities on that patent, which means for every year that the patent office maintains your patent, you have to pay fees for that. So there is a 1 year fee, 3 year, 5 year, and so on, and you have to pay quite a bit of money. So those are called annuities. So that's the fee that you pay for patents. For example, in US, US patents are valid for 20 years, but subject to maintenance fees. So first milestone is 3.5 years, then 7.5 years, 11.5 years. At that time, you have to pay additional fees to maintain that patent in the patent office. Otherwise, that patent will expire. In some cases, for example, companies after 7.5 years might say, okay, now it's no more use in our product, so we don't want to keep paying for it. And at that point, they might drop this one. After the patent has expired or somebody has not maintained it or paid fees for it, anybody can make use patent without permission of the patentee, provided the matter is not covered with other patents. So that's where we file continuation in parts patents, so that we have a longer duration of rights to that patent. Now, where does the idea come from? There are a number of different ways of looking at that. Again, I'm quoting here Thomas Edison, who said opportunity is missed by most people because it is dressed in overalls and looks like work. So while you're solving problems, while you're doing work, while you're designing your product or services for your own company, you're solving problems. And while you're solving problems, there may be novelty in the approaches that you have taken. There might be novelty in the product that you have designed. And that novelty by itself is that patent idea. But if you miss that and if you just say, oh man, okay, this is so hard, I don't think I can solve this, then you are missing that opportunity. So that's Thomas Edison's quote on that. By analogy, also, you can come up with ideas. There are a number of examples of that. I think in school, you probably have heard about these things. That Newton saw a falling apple and then he thought about gravity. Now, it's an idea. That's not a patentable thing because gravity is a natural law. James Watson came up with this helix model for DNA based on the serpents that he had seen in a dream and so on. They can come by intuition, by experimentation. Also, you can get a lot of ideas, and experience also gives you ideas. Now, in this cohort program, very first lecture by Dr. Mashelkar sir talked about this assured framework. And that's another way of looking at innovation and IP. That the assured framework stands for affordable, scalable, sustainable, universal, rapid, excellent, and distinctive. And the point that Dr. Mashelkar was presenting in that book, as well as in this assured framework, is that you need to have all of these in order to make your startup successful, not just in short term, but also in the long term. And to do each of these, you need to have innovation. So, and when there is an innovation, there is a IP, intellectual property. So let me give you an example. I worked for many years into a field of inertial sensors. These are sensors that are used for navigation. Now, 20 years ago, 30 years ago, these sensors were so expensive that they were only used in aeroplanes. These are, for example, accelerometer sensor, gyroscope sensors. These are used for controlling the motion of a plane because the plane can tilt, it can go up and down and so on. So all these motions are monitored using these sensors. And they used to be very expensive equipment. That's why it was limited to that. They were also bulky. Now, 20, 30 years later, each of you, if you're having a smartphone, you have that sensor in your smartphone. So it's that affordable and that scalable. How did we change that? How did we transform that, make it affordable so that it's as cheap that it can go into every smartphone? And so that requires innovation, right? That required completely new idea, new way, new technology of scaling these inertial sensors from where they were used in the past, how they were constructed, to something that's so small, so tiny, and so lower cost or cheap enough that every cell phone manufacturer can put that. And obviously, they are passing that cost on to you as consumer, but you can afford that. So that's where the affordability, scalability comes in. And we shipped hundreds of crores of these. So they are into my own sensors are into 100 crore smartphones. So you have to make it that scalable and that affordable in order to have that go everywhere. That required innovation. And that's where the patterns that I showed you in the very first slide, some of those came from that type of innovation. Now, excellence, the last 2 points there are excellence and distinctive. So both of those are really referring to something that's a non-obvious idea, distinctive. And excellence, anytime you have to make something excellent, there is innovation behind that. And so it's both ways. In order to make it into that assured framework, you have to be excellent and distinctive and innovative. And vice versa. Once you are into that assured framework, if you believe that your company has worked on a product which meets these criteria as affordable, scalable, sustainable, and so on, In order to make that affordable, in order to make that your product so differentiated, you must have done some innovation, and then you need to capture that. You need to capture that by patenting that innovation. So that's how it's interrelated to that. You need to have innovation in order to fit into that assured framework. But if you believe that you are fitting into that assured matrix, then that also implies that you have certain patent or certain IP that you need to protect. When do you know it is worthwhile to protect or file a patent? So for startups, your idea, if it is a foundation of a company, you must file that patent because that's the core of your business. For example, if somebody there were some companies in our court, and I think in this court also we have companies who have worked on food technologies. So they have come up with some new recipes for making certain type of food, whether it's a soup or whether it's nutrients. So that's a novelty. So you should file that because that's core to your company if you're trying to make a business out of that. Solving a difficult problem that can get competitive edge. So, for example, I talked previously about these technologies where we could go into a lot of smartphone components, and many companies believe it. Once there is that bigger market of billions of smartphones, every company or companies who want to go into that, they are going to compete with you. So you need to have competitive edge, otherwise it's very hard to sustain yourself or survive into that business. So in order to get that, you have to file patents, you have to file IP. Corporations have patent committees. Again, every company creates this local or internal infrastructure that has patent committees and certain criteria that's used to differentiate what IP needs to be filed, because again, there is a cost involved in this one. And then there is this cost versus benefits, return on or investment calculation, ROI calculation, and sellability as well, which means if you put this new idea into a particular patent, is that going to create more value for your customer or for your company? So that whether the sellability is going to increase, that's the criteria in order to find out whether that's something worthwhile filing. Now, we talked a lot about patents, but there are other intellectual property forms as well. And those are trademarks, copyrights, and trade secrets. And these are equally important. So that's why I want to spend some time just going over these ones. Trademarks and service marks are any word, slogan, a symbol, design, or combination of these. So these are used for identification of goods and services, and they distinguish it from other product and services. So some examples are, you see that Coca-Cola, if you have seen those cans, the Coca-Cola word is written in a specific way, or Nike, the word, and then the check mark there is drawn in a particular way. So that becomes a trademark. On the other hand, there are some service marks, which are source of services rather than goods. So for example, for Coca-Cola, this can is a goods, whereas for FedEx, it's a service. But you can see the way they have written that FedEx with two different colors and with a background and so on. So all that, the way that's drawn, that's service mark. So that is IP of that particular company if they file that. And those are good examples for you to think about if you have a certain trademark or logo that you need to copyright or file. Copyrights are original work of authorship, fixed in tangible medium of expression. So you cannot say just a speech is copyrighted. These slides are copyrighted because there is a medium, which is this PowerPoint electronic format. But if I were to just have a dialogue with you, that may or may not be patent. But if that same dialogue is now recorded in a video, that can be copyrighted. So for what can be copyrighted? Literary work, musical work, drama, pictorial, graphics, sculptural work, motion pictures, sound recording. That's the reason I gave that example. That, for example, my video here is copyrighted. Audio visuals, that's part of this, is copyrighted. What's not protected is, again, ideas are not protected. procedures are not protected, concepts are not protected, principles are not protected. And term of copyright is life of author plus 70 years. So that's why you see some books are then beyond that copyright thing, and then they can be copied at that point. Trade secrets, these are must that get used into business and provide a key advantage over competition. To give some examples of these ones are manufacturing processes, recipes, formulas. For example, the way Starbucks makes coffee. Now, there are several other coffee shops which also provide coffee, but Starbucks would say this is our trade secret, the way we provide our coffee. Or there would be other brands like McDonald's would have their own recipe in terms of their burger. So all of these are recipes. Those are trade secrets. You cannot just write it down saying this is my patent, but those are trade secrets. These are not filed, by the way. These are, unlike patents and trademarks, these are not filed, but you maintain that. You could just say that this particular recipe is my trade secret, and that's it. You don't have to file it in an office. So final thoughts on these patents. Filing and protecting intellectual property is very important asset for the startup companies. When we discussed the previous sessions on business model canvas and value proposition and so on, you will see that there is a portion which is related to resources or your assets and so on. That's where your patents go in. Patents is a very important asset for your company. There is also barrier to entry portion or SWOT analysis and so on. So that's where also your IP go in. So that's really important for all the startup companies. And IP is more than just patents. That's the reason we went into that copyrights, trademarks, and trade secrets. Now, I want to share with you that there are several government incentives for both state level and central government level in India. So make use of that. The latest versions of that, I think we'll post it at some point because that keeps changing. And last year, I think we had posted that when I had given similar webinar 2 years ago. So we'll try to post it again so that you have access to that. And you have to keep innovating to become a leader. It's not a one-time thing that you came up with the idea and then you filed it and then you're done with that. If you want that idea to be sustainable, you have to assume that a competition will come up in a year, 2 years, 5 years. And that point, you have to innovate more on top of what you have done before, or maybe you have to do another disruptive thing and come up with another idea. If you want to stay in the game, you want to stay ahead of this competition. So you have to keep innovating as a leader. Now, as part of this cohort, after every webinar or after every topic, we also give assignments to startups. So here is the assignment portion for related to this intellectual property. I want you to list all the core ideas of your startup company or products. So start thinking about that. If you have come up with a particular IoT idea, then what's the core idea? Is it something that's really differentiated? Is it novel? Can it be patentable? Same thing on food technology. There are a few companies in the food sector. So if you come up with a new formula for something or new dish that you're coming up with, is that recipe something that's either a trade secret or whether it's something that differentiates you so that you can protect that. Then the second thing is, what is the barrier to entry for your competitors? That's very important in any startup, in any new company, that you have to think about why wouldn't somebody else come up with the same thing? What protects you to be either in that game or be leader or take a certain share of that market as opposed to your competitor? Is there IP prior art that is barrier to your core idea? So this is kind of on the defensive side. The previous one was on the offensive side. This is on the defensive side, that are you infringing on somebody else's idea? So you have to also make sure that that's not the case. And for that, it's better to be innovative and be on the offensive side and file your IP. In addition to that, what other core IP does your company have, which is copyrights, trademarks, trade secrets? So just think about that. That will become the foundation of IP. Is the IP other than trade secrets filed? And if not, why? So come up with a roadmap to protect your IP. You might say, okay, I have an idea, but okay, I need another year to prove that, and I'm going to file at that point. If that's the case, then I would say, okay, file provisional now, protect that idea. Within that year, develop that idea, prove that idea, and then you file non-provisional ones. So that's the IP policy there that you have to chalk out, or the roadmap to protect your IP, especially something that's core to your company. So with that, I want to end this webinar. I encourage you to look at this assignment and post it, post the relative to or specific to your own organization, your own company. Post this one. It could be an Excel form, it could be a Word document, and then we'll discuss that during breakout sessions when this particular IP topic is being discussed. In the meantime, if you have any questions on this, you can reach out to me on Slack, or you can reach out to your mentor in order to find out if such certain things are not understood, or you can post your own questions. And in the day or that week that this IP topic is discussed, I'll be happy to address your questions. So thank you, and good luck to all of you to innovate.